Welcome back, listeners. It is season 3 of Real Smart, and I am Maura Neal, and this is Cheryl King.
Yes, yes, yes.
And we're back.
And we went with video this time, right?
We did all new and improved Real Smart podcast.
There you
So,
go.
Cheryl, some of our listeners might have thought that we gave it up, that we got too busy, that we didn't have anything else to talk about, which means they really don't know us very
Right.
well. I feel like every time we get together, whether it's at a closing, at happy hour, at a class, we should just record because every conversation is a podcast episode. But that's really why we're back. We took a little break. We sort of had to step back and reevaluate the process because it's a lot of work. But we enjoy it too much to let it go completely. So here we are, season 3.
Welcome, welcome.
All right. Well, we go ahead.
Oh, yeah, and I think part of it was also we wanted to sort of reframe and look at what are the things that we want to be talking about. And when you made the quite clearly joke about we had run out of things to talk about, there's absolutely no possibility that that would happen. I think it was more a matter of the things that we want to focus on and take care of and address.
Right. And in real estate, especially right now in 2024, the state of everything going on, it is very literally impossible to run out of things to talk about, especially for two people who sort of eat, sleep, and breathe real estate and policy and contract forms and all of those things. So I'm glad that we're back, and hopefully our listeners are too.
Absolutely. And there are a lot of changes that are coming, and as we went through and discussed what those things would be, some of the things that agents are talking about right now as it's happening this moment aren't really happening in this moment yet. Obviously, we need to be planning for those things. We need to be preparing and framing how we're going to conduct business going forward. But what we wanted to focus on preliminarily is let's talk about what's happening in the here and now and work our way into the things that will be happening, presumably, with settlements and other things that are coming down the pike, but aren't there yet. And if anything, in the month of June, I learned it was that at any point I was ready to have discussions, something else came up and something else happened, and there was some other movement. And so I think we need to let a couple of things settle. But I definitely think that we want to help agents get out ahead of it.
That's right. And to all that to say, we of course have some future episodes planned that will be addressing compensation conversations, how to deal with the changes that are going into effect as of August 17th. Anyone who is an NAR director or on their local or state leadership is getting those email reminders from Katie Johnson at NAR reminding us that August 17th is the drop date for some of those changes. But of course, because the lawsuit settlement is still very much a proposed settlement and has not been approved yet, even though those changes will go into effect on August 17th, approval or not, things will continue to evolve. It is a living, breathing beast, and we will still be dealing with potential lawsuit settlement changes. We will still be looking at that guidance from NAR. We have a few episodes planned. I'm sure there will be more. And then, of course, there is all the other stuff in real estate news that is yet to happen. But for today, for our first episode back in season 3, we want to talk about something that has already happened. In fact, it happened. Nobody knew about it. It sort of took a lot of us by surprise. And I'm thinking there may even still be some listeners who are unaware of the change.
I think that you're probably right as someone who's been teaching our mid-year forums in terms of this is a document that went live way before our mid-year forums did, unbeknownst to any of us. I will, and these are the agents that are actively coming to classes. They're clearly engaged. They know they need to be there. It was packed houses for all of the change classes that we did in Georgia for the July 1 rollout of GAR's new forms. And there were still a lot of people. I could tell from the looks on faces, even if they weren't saying anything, that there were some people that were caught by surprise.
That's right. So what we're talking about, of course, is the new form that the EPA released on April 24th, by the way. The date on the form is April 24th, 2024. There is a new lead-based paint exhibit, and there is now officially a separate one for tenants than there is for buyers, which was a big change. But even more importantly, this change happened and nobody knew about it. And I can tell you how, I'll tell a little story about how I found out about it. So April 24th is when we know the form is dated and when it appeared on the EPA website, but I hadn't heard anything about it until May 8th. So about 2 weeks later, I was sitting at a breakfast meeting at NAR's mid-year meetings, legislative meetings, and a friend of mine, former Alaska Realtors president and former Region 12 RVP, Angie Talent, shout out to Angie, came into breakfast and she said, "Hey, have you guys seen this new lead-based paint form?" And we were all shocked. And this is a table full of very involved, very educated realtors, and none of us had seen it. And immediately we all whipped out our phones, looked at the form first, and then started texting and emailing. I emailed the Georgia Realtors leadership team as well as our legal counsel. They were all emailing NAR's legal counsel and NAR's leadership team and their own states, because 2 weeks had already gone by, which means 2 weeks that realtors could have written leases or offers and been using what we thought was the appropriate EPA lead-based paint exhibit.
And I think what anyone should realize is that realtors are not going to the EPA site and pulling this blank form every time that they are using it. I would imagine that many states are like Georgia, that we take those and we incorporate them into our document packages so that they can pull in the property address and the buyers and all of those other things. And it is frustrating enough. We have had times in the past when the brochure has changed and we weren't notified about that. And that part I, don't like it, but I understand it a little bit because it's a brochure, it's out there. Not everyone probably takes the brochures and incorporates them the way that we did. The main problem that I have with the utter lack of notification for this document is that the change was directly related to real estate agent obligations. And
Right.
there was not one attempt to reach out or publicize or do anything that told the people that are now charged with responsibility that this responsibility has been created.
That's
That's my
right.
problem with it.
And so here's the big change, since I'm sure if anyone's listening right now and they aren't aware, they're probably like, just get to it. What has changed? So the change is that they've added a place for the buyer's agent to initial. There's always been a blank for the seller's agent to initial, the listing agent, acknowledging that they have essentially that they've given that brochure or some version of education and notification to the seller of their obligations to disclose the presence of lead-based paint or the possible presence of lead-based paint, right? So the listing agent sits down and does the listing paperwork with their seller. If the house was built before 1978, they have the seller fill out the first two sections, and then of course they initial and sign, and their client signs, and then that is given to any potential buyer so that they can incorporate it into their offer package. The change is for the buyer's agent to initial that they have notified not their own client, not the buyer, but the seller of the seller's obligation, with the caveat that it's only required if the purchaser's agent, so in Georgia, we say buyer's agent, receives compensation from the seller. So now we have a lot of questions, don't we, Cheryl?
Absolutely. And it, there's an article that I'm working on right now, and I've got a working title for this. And my true feelings about this change, what was changed, how it was changed, and the utter lack of communication was that a federal government that is charged with protecting people is instead trying to prove a point. And I could understand if a buyer's agent is supposed to explain to their own client the importance of lead. And in fact, I would invite that as something that needs to happen, because I do know that people will make jokes about don't lick the walls and some of these other things. I don't make light of lead and what it can do, particularly to little people's brains, but any adult as well. And so my issue with this is clearly the way that they framed this, and by couching it in the way of if there's compensation that's being paid from the seller to that agent is nothing except a reaction to the commission structure suits and all of the accusations that have been made against real estate agents.
That's right. It's definitely not a coincidence. It is one government agency taking a page out of another government agency's book, right? The DOJ has stated point blank that they don't believe that the seller or the listing broker should in any way be compensating a buyer's agent. That has been stated. And if it is too coincidental to actually be a coincidence, it's too similar to be a coincidence that in April, at the same time that some of these beliefs, directives have been coming down from the DOJ, and that NAR has been working through the details of the proposed lawsuit settlement regarding how compensation is advertised. It's just too much to be a coincidence that all of a sudden the EPA says, oh, if the seller is compensating the buyer's agent, then that buyer's agent also must be responsible for letting the seller know of their duties. And of course, we know when anyone who has taken the Georgia Realtors mid-year contract changes class, the only real change that we've made to our version of the form is changing the word purchaser to buyer, because of course we want it to be consistent with what we use throughout our contracts, and we use the word buyer, but that has been incorporated now. And so I guess the next question that I have for you, Cheryl, is how do we define whether the buyer's agent is receiving compensation from the seller? In other words, technically, when we look at cooperative compensation, right, which is still currently advertised in the MLS, but is soon to go away as of that August 17th date, will no longer be advertised. But in a traditional, or I guess typical, because there is no standard, in a typical real estate transaction, which most of us are accustomed to these days, the listing agent discusses and negotiates compensation with the seller. And if the seller does authorize the listing broker to share monies with the brokerage that brings the buyer, that money is going from the seller to the listing agent to the buyer's agent broker. But is that considered the seller compensating the buyer's agent, or is it only when it's directly negotiated in the contract that the seller is directly paying the buyer's brokerage? How do we think that the EPA is defining that, or are they even concerned?
Well, first of all, the other change we made was to take the compensation note out of a footnote at the bottom of the document and put it up where it should go so that people will actually see it, because our GAR forms are not meant to hide details. They are meant to explain them. But the the definitions in our forms, just as you said, with cooperative compensation, it really truly is coming from the seller broker to the buyer broker. In fact, if there is no buyer broker, there's nothing that is shared. And all of the compensation that a seller agreed to pay their broker gets at the end of the day. So it's only if a buyer comes in with an agent. The only way, and so when we are looking at this, and when we are looking at the way that our Georgia forms explain things, which is obviously going to be what Georgia agents are looking at, it is we wouldn't see that as the seller paying the buyer's agent. Where you have to go in order to find what they mean is you have to go back to the whole code. And I hope you got your law degree, because if you didn't, I don't know that you know how to find it, and I don't know that you know where to find it. And so I went through the code section, and they did define who a real estate agent is. They didn't define who a buyer's agent or a purchaser's agent is, but they just defined what an agent is. So what they said was an agent means any party who enters into a contract with the seller or the lessor. So that would be the listing broker, the seller's broker, right? including any party who enters into a contract with a representative of the seller. So that means that it also includes buyer's agents who are paid cooperatively from the seller, from the seller's portion, seller's broker's portion of commission. And I don't think that that's clear on the form because you'd have to go back to the actual law. I will say when I posted this out, there were some comments that I completely understand, and it's most of the reason that we decided to make this the first episode this season. There were some comments that said, if I'm not being paid directly by the seller, this isn't going to apply to me. And I can tell you that based upon the way that the word agent is defined in the lead-based paint regulations, that is untrue. So the buyer's agent has responsibilities whether they receive that compensation cooperatively or directly.
And I think that it's also important when you to clarify, because you mentioned any party entering into an agreement with that seller's agent. When we sign the instructions to closing attorney, or in other states, they may call it different things, such as a commission agreement or a compensation agreement. I'm sure there are 50 names in 50 states, right?
Right.
That is entering into an agreement to be paid. So ultimately that checks that box, right? That satisfies that portion of the definition that even if you're not the listing agent, the seller's agent, if you've entered into an agreement with the seller's agent for compensation, you now are being paid in the eyes of the law, in the eyes of the code, you are being paid by the seller.
That's correct.
Yeah.
So it really it gets us to the point where unless the only compensation that an agent gets is from their own purchaser directly, then this regulation and this form and the completion of this is going to apply to them. And we already had people that were struggling with making sure that these things got done. So we just doubled the struggle, I guess, is what I'm trying to say.
Right, right. And so I guess though, if we're working we're working from this definition that you just gave us, which is codified, right? It's part of the law.
That's correct.
So then we have to look at our own code of ethics, because we now, as realtors who want to do things right, who want to do things correctly, not only in the eyes of the law, but on behalf of our clients, how does this affect our definition of agency and our obligations under the code of ethics? Because now, unless, as you said, I am only being compensated directly by my buyer for my services as a buyer's agent. In other words, I've now shown a listing that my client wants to purchase. That seller nor that listing broker are offering any compensation to the agent who brings the buyer, but that's okay because I got my buyer brokerage agreement signed. I've already negotiated my compensation with my client. We're going to move forward for them to buy this house, and it happens to be built before 1978. I am now obligated by the EPA to notify the seller, who is not my client, of their obligations under the law. How do I do this? I mean, I know what I'm going to do. So let's back up for a minute and talk about what does the code of ethics say, Cheryl, and how is this possibly entering into unsafe territory? And then I'll tell you how I think I'm going to fix it for my own business.
And I will say, because in most states, I would assume you're going to have two different things that you're concerned about. If you're a realtor, and in some states, this will obviously change with some of the settlement as well. But in a lot of states, almost everyone is a realtor. In most states, the great majority of agents are a realtor because of the value that brings. So with regard to realtors, what we're looking at is the code of ethics. And Article 16 of the Code of Ethics says that we're not going to engage in any practice or take any action that is inconsistent with exclusive representation or exclusive brokerage. And there is, within many of the code sections, there are what we call standards of practice. And it is because, unlike the way the federal government tells us if you're doing it right or wrong, the National Association of Realtors gives you specific examples of things and says, this is what you can do. This is what you can't do. We are not trying to hide the ball. We are trying to create ethics in our industry and provide explanations. So, Standard of Practice 16.13 says all dealings concerning property exclusively listed or with buyer tenants who are subject to an exclusive agreement shall be carried on with the client's representative or broker and not with the client. We are not supposed to make an in run around the other agent who is representing that client and start talking to that client directly. And the only exception to that is if the other agent has consented to it, like, yeah, you can reach out to my client about that, which most smart agents are never going to do to begin with for all sorts of very good reasons. Or if the dealings are actually initiated by the client on the other side. So if they call you, you don't have to hang up on them. You are allowed to have that conversation, but it should be very short and limited to the purpose of their call. So you have that, but also I would assume in a great many states I would hope in a great many states, there are laws and regulations about licensees. And so particularly in Georgia, where we have forever had real estate licensees, we are all real estate licensees, and some of us also elect to be realtors. You also have what we call license law, and it is important enough that real estate agents are required to take license law classes every 4 years based upon their anniversary. So it's something that obviously we want to make sure that they're aware of. And what you have, it's 434025. It says that you're not supposed to negotiate directly with a client who is represented by someone else. And to do so is defined as an unfair trade practice under the Georgia Code. And this requirement or limitation exists in law and in ethics because we are supposed to honor those representations. We do it with legal representation as well. If I have someone who's represented by counsel in a legal dispute and I'm counsel on the other side, I should not be calling the client on the other side. I should be working with their legal counsel because they're represented. And the purpose of representation is to take care of them and not have someone make an in run around you who has their own motivations because they're coming from the other side of the deal. So there are definitely legal restrictions and ethical restrictions. And I would imagine that something similar probably exists in all 50 of our states.
Right. I would imagine so too. It makes logical sense. So here's what I'm going to do. And you and I have talked about this a good bit. So I already know that you have vetted it and it has your stamp of approval. But I think that, because we are navigating not only legal, but ethical possible pitfalls, also, we are trying to navigate the EPA's definition. What I'm going to do is in here in Georgia, we have a form that is F816. That's our generic notice form. And I'm going to write onto that form that the buyer's agent hereby gives notice to the seller of their obligations under the code. I'm going to write on the form that the buyer's agent hereby gives notice to the seller of their obligations under the code, of their responsibility to ensure lead-based paint compliance. And I'm going to attach to that notice the lead-based paint pamphlet, which is our CB04, and possibly even a new form that I just discovered, Cheryl, called disclosure information concerning lead upon transfer of residential property, which really just outlines those responsibilities. I know that form's existed for a while, but I just found it the other day. And why not cover all of my bases? But
yeah,
I
it's
think
basically just the words of the code pasted into ours. So we're taking what the legal words are and saying, and I think part of that is in case anyone doubts what you're saying, if you'd like to read it yourself, here it is, right?
Right. And I think that the passing that along to my understanding of our purchase and sale agreement is that it does state that notice to the agent is considered notice to the seller, right? Because that's how we deliver a binding contract, we deliver an offer, we present an amendment, right? So having the ability to send that to the listing agent and say, under my new responsibilities with the revised lead-based paint exhibit, I am delivering this notice to your client via you. That way we don't break that boundary. We don't break the law regarding contacting another person's client. And the only question I have, and this is specifically for Georgia forms, is that GAR form F816, that notice form, it's really only meant for either the buyer or the seller to give notice to each other. So just for
And
us,
the reason for that is that our contracts and the law say both agents can receive notice on behalf of their client, but they can't be the person who gives a notice with regard to any of the other things that we may have in our contracts, because nowhere else do we charge a buyer's agent with the obligation to notify someone on the other side of the deal.
right, right. So for our purposes, for realtors specifically in Georgia who are listening, because those forms are copyrighted, do we have the ability to make that minor change? Because right now it says buyer and there's a little box, or seller and there's a little box that you check, hereby gives notice. So is it acceptable, and how would you navigate that to make that change to that form so that it's buyer's agent gives notice to seller? Or would you just write it in?
I would write it in and basically add another checkbox in a separate line, right? Because anything not checked off doesn't apply. So the first part of the sentence would have no force or effect. So you would just create a second line, which is normally where you would be adding the thing that is the notice only. But what you would also add is a little check, or if you can, like a little box with a check inside of it, and say that the buyer's agent hereby gives notice. You can use a GAR form in a way differently than it was intended, as long as you're not editing that form in a way that eliminates anyone from being able to tell what it used to say. So you can strike things, and you don't have to strike anything up at the top. I would strike at the bottom party, because the buyer and the seller are the parties to the contract, and I would put in broker on the signature line. But you would simply strike through that party, or strike through that whole line and type additional language on there. But you can certainly use that. And I do think that there is a possibility, I think it will at least be discussed, that some notice form be created. But when you explained the timing of these forms, we actually, as trainers, got the copies of these forms before we were actually able to put together a new lead-based paint document. So I got a set of documents, and I was in the parking lot at a brokerage office ready to teach the first class that I was teaching on the changes, when I found out that the following day the forms committee would have a meeting and we would be discussing this, because it had just gotten to everyone's attention.
And my last question regarding the use of that notice form, because I'm one of those people, I want to cross the T's and dot the I's, right? And for me, giving notice to someone, at least the logical part of my brain says that there should be some sort of acknowledgement, but it would be unrealistic to have the expectation that a seller would give us a signed acknowledgement of receiving that notice, right? Like the notice form and the pamphlet. And they're probably thinking, I already got this from my own agent. So as long as we include some verbiage that notice to the seller's agent shall be considered notice to the seller, and then we put it in our broker's file and it stays there for, the mandated amount of time, 7 years, right? Is that correct?
Three for this one.
Oh, 3 for this one. That should cover us, right? So for anybody who's a little bit nervous and a little bit worried, that should be enough coverage, because of course we don't know. We don't know how they'll be policing it. We don't know how else to cover our bases, because there's been no guidance from the EPA, and that should be sufficient, right?
I would never promise what a federal agency is going to do, and I already don't see a lot of good faith coming out of them. I do think that it should. I don't think that they can require you to break a state law. I don't think they care about the Realtor Code of Ethics at all. So let's just throw Article 16 out the window. But in terms of what Georgia law allows for, that's going to be a federal versus state argument at that point, and I'm certain not the only one. So I do think that it is the best that you can do. We have one other form in our system where we ask for acknowledgement that something has been given to a seller. So we may go down that road at some point, but I will tell you that one is is it is a document that verifies that an offer or a counteroffer has been presented to the client. And it's because it is both a legal and an ethical obligation to present all offers to your client. And there have been agents who have gotten the feeling that the other side may not have done that, mostly because they said, your offer is so ridiculous, I'm not even going to give it to my client, which is just clearly admitting that you are violating both law and ethics. So we did create a form that is an acknowledgement, but even then, we couldn't require it.
Right.
It's optional. It's something that you ask for. So I don't know that we can mandate that the other side responds to us. Certainly, this will be something that we discuss, because we really do try and build these forms in a way to protect buyers and sellers and real estate agents and make everything clear and give everyone what they have contracted to get. So certainly we will be discussing, and in more time than we had to just slap an approval on this revised form, because when we made this change, these documents were already starting to go out to the doc systems. And so we were given no notice and very little time in order to get this thing out for everyone. And I would invite people to stay tuned and see what may come up, January 1 in terms of changes. But in the meantime, we have to figure out some way to navigate this. And I think that as it stands with law and ethics and abilities and everything else, I think your plan's the only viable plan.
Well, and I do like that maybe there's an additional opportunity at some point to either put it into the original offer, right?
Right.
Put it into the offer, create a stipulation, which means that I would be coming to my stipulation expert, Cheryl King, to put something into the purchase and sale agreement that states that with the signing of this contract or a subsequent counteroffer, the seller acknowledges that the buyer's agent fulfilled their obligations in paragraph 4B of the lead-based paint exhibit. And maybe that's the most sufficient acknowledgement that we'll be able to get,
Yeah.
without.
Well, and you as a buyer's agent would have the opportunity to put it in there, because you are making an offer, and it's not going to be something that a seller counters on, right? They're countering on purchase price and seller pay closing cost and closing date and all of those other things. So I do think that it is a smart idea to have some acknowledgement in there, because that's the one document that you can guarantee that if you go under contract, you'll be able to get in some executed form.
That's right. Well, this might be a good time for us to take a quick break, and we will be
Sounds
right
like a plan.
Welcome back. We are talking about lead-based paint disclosure, the new exhibit that dropped from the EPA on April the 24th of this year, and the changes that we are having to make in the real estate world when we are disclosing lead-based paint on those properties built before 1978. Right before the break, Cheryl, we were talking about getting the seller to acknowledge when we, as a buyer's agent, fulfill our duty in the new lead-based paint disclosure exhibit, and we send over our notice to the seller via the listing agent of their obligations to disclose lead-based paint. And I had mentioned that I'm a little concerned that I don't get any sort of acknowledgement, because of course I can't require that the seller acknowledge that they've received my notice. What do you think about putting a stipulation into the offer?
I think that it's an excellent idea, and I think that this is the one place where you're going to be able to control the language, and you're going to get a seller's signature. And so, and again, the seller is not going to quibble with this particular thing. So I think that what I'm going to do as we get this thing ready to air is to go ahead and put something together. Special stipulations are one of my superpowers. And I have my Smart Sips website where I put things, because I spent 15, 20 years writing stipulations for people, a lot more probably in the last 10 or 15. And when I was recreating the wheel over and over and over again. So I started publishing everything to the website so that I would be able to refer back to my own work and send somebody a link so that they could go grab some of the stuff. And I do have a lot of agents who will say, I checked the GAR steps first. I did the right thing, because there's 13 pages of GAR stipulations for everyone. And I checked your website. And so, can you help me with this? So I think what I will do is put something together and we can put a link to that in the show notes so that people can go and grab it. Because I do think that I am very fearful that the federal government will say you sending notice through the agent wasn't enough,
Right.
regardless of what law says and regardless of what ethics say. So I feel like that is, in terms of the path of least resistance, getting compliance that way is probably going to be your best bet as an agent.
Right. And if anyone listening has not gone to Cheryl's Smart Steps website, smartsteps.com, of course, there is a link in the show notes for you, but it is such a great resource. And again, I am one of those people. I check the GAR steps first, 13 pages. I do a keyword search in the PDF, see if I can find what I need. If I can't, I go to Cheryl's site. If it's still not there, then the next thing I do is reach out to Cheryl and say, I think this one might be able to be modified, or is there one that we can just modify, or can you write something new for me? So along those lines, though, another nuance of the lead-based paint exhibit, which I feel like perhaps is not as well known, is that even though the buyer and the seller are both required, and the agents are both required to sign this exhibit and attach it to contract for any house built before 1978, the buyer cannot sign before the seller. In other words, just like a seller's property disclosure, you would never have a buyer sign the signature page and then give it over to the seller and say, please fill this out. So the seller
Exactly.
must fill it out first. But what about those circumstances where perhaps you've had trouble reaching the listing agent? Perhaps they're newer and they forgot to have their seller fill it out first. So we're waiting, but the buyer doesn't want to lose the opportunity and they want to go ahead and submit an offer. We obviously can't just have them fill out their portion of the lead-based paint exhibit and submit it with the offer. So what do you suggest we do in that case, Cheryl?
Yeah, we certainly can't because they're acknowledging information. So if the
Right.
information is not there, then they cannot acknowledge it. And the first thing we do is try and teach listing agents the best way to do these things. And anything that has the word disclosure in it in our Georgia Association of Realtor forms are what I like to call seller homework. And so those are the things that you give a seller as you're taking the listing so that they have time if they need to refer to something else, get additional information. That includes a seller's property disclosure, a community association disclosure, if applicable, a lead-based paint disclosure, if applicable. And what you are supposed to do with those is once you look at it to make sure they actually filled it out correctly, which is a lost art. But once you do that, the best thing to do with these things is to put them into the listing, into the MLS, so that they can be grabbed and used and incorporated when the offer is made. What I hear, though, from buyer's agents and from their brokers over and over and over again is the buyer really wants this house. The seller side is not responding or not responding in a positive way. And we are the ones who are saying we can't make an offer until we have this. And yet they're accepting other offers from other people because the seller's agent doesn't care and the other buyer's agent doesn't care. So what you don't want to have happen is the agent who is following the law, protecting their client, be the one whose client loses out on a deal. I'm not fully in love with this stipulation yet, although one of the brokers that I was talking to in particular about this issue thought enough of it to post it inside of their real estate group. So I think she likes it a lot. I think it still needs a little bit of reworking, and I will certainly do that in the next day or two. But what it says is the seller acknowledges that, and this would be a stipulation that you would include in the offer. The seller acknowledges that under federal law, and then there's the actual code, just in case they want to go look it up, the
Right.
buyer cannot become, and these are the words from the law, obligated to purchase the property until the buyer has received the lead-based paint disclosure from the seller. Seller and buyer therefore agree that the due diligence period shall commence on the day the seller provides the lead-based paint disclosure, which buyer will sign and return to seller within 1 day. when we have these other disclosures that we want, the CAD needs to be there. The association disclosure needs to be there on the day. The seller's property disclosure doesn't necessarily, and we have some stipulations that say it'll come later. This one cannot come later. There is no, you can't write the to be provided in 3 days or any of those things, because it is before the buyer becomes obligated. So what we are trying to do is to keep the buyer from being obligated. And in theory, they are not obligated at any point during a due diligence period. But I also want to make sure that it is even more clear. And we do have GAR stipulations. There is one about the utilities not being turned on. And there is a stip that says the buyer's due diligence doesn't start until the utilities are on. That does a couple of things. It means the buyer doesn't lose their days of due diligence where they can't even reasonably inspect it because the utility is not on. So there's going to be things they can't test. But also what it does is hopefully motivate a seller to do the thing, because every day that they don't do this is basically a free look day for that buyer. So we do that in order to motivate them to do the things that they are supposed to do. And this is much better than saying we're not going to go binding until, because what you don't want to have happen is to have your contract not go binding and the seller gets another offer in the meantime that they like better. So what you want to do is lock a seller in, but not lock a buyer in. And as I said, I'm still playing around with the wording a little bit, but I think that this is really our best bet. And I think framing it by explaining that this is the requirements of the law may help a little bit. So what are your thoughts about it?
The only improvement that I can think to make is that none of the timelines should begin. Nothing. Financing
Yeah.
contingency, appraisal contingency, earnest money due date. I mean, really, all of the timelines should start upon the delivery, because we also don't necessarily need the lender to start doing work. We don't need anything other than it to become binding, but all of the timelines would begin on the date that the seller delivers that document. But I think
And I also like that as a change, because number one, you could be in a right to request repair contract and not
right.
in a due diligence contract. So it presumes that there is due diligence, which is the vast majority of our contracts. And to your point, that would keep any of the appraisal contingency, any of your other contingencies or deadlines would then not run. We could even say that they're not even including the deadline for earnest money doesn't begin until, and just bootstrap all of those things in there, which means that right now the only party that has to perform is the seller, and the buyer literally has to do nothing until that lead-based paint disclosure is delivered. So this is why we like to talk about these things, right?
And that's why every conversation is a podcast episode, at least
Exactly.
the grain. But one of the reasons that this cannot be a to be delivered later is because it not only it's federal law, right? But because there are pretty extreme penalties attached to executing this document incorrectly, not executing it at all. So let's talk about that, because they are, if anything, lights a fire under an agent and a seller's butt to make sure that these things are done properly. It's the penalties. So talk to me about the general penalties for filling out the lead-based paint exhibit incorrectly, because I feel like this number is misquoted all the time, and we are getting, in some cases, just wrong, outdated information about the actual penalty per error, right?
Correct.
So let's talk, scare us a little bit.
Scary. So forever we were all teaching the classes, and I will say that when I discuss lead-based paint in a number of classes. I discuss it obviously in the disclosure, inspection, and conditions of property. I discuss it in the in-depth contract classes. I discuss it in the special steps classes. There's a lot of places where this traipses into it, and I will ask the room, what is the penalty? And there are some people who will say 10,000, and that's just a number that they grabbed, that seemed like a decent number and scary enough.
Right.
For years and years, the quoted number was 16,000, because it had been 16,000 for a number of years. In 2011, they started increasing this number every single year. And it was last year, it was 21,018. They just issued, and when I checked 2 weeks ago, it wasn't there. Now it's there, and it dated itself back to February. But the penalty amount for 2024 is $21,699. And that is, to your point, per error.
Right. So, and when we say per error, let's give a couple of those examples, right? So, for example, a buyer's agent who fails to initial the new box because they're unfamiliar with it, that is a $21,699 error.
Correct.
A seller who incorrectly fills out, there are two places, right, where the seller
Right.
must check a box and initial. A missing check and a missing initial, that's two errors at 21,699 a pop. Missing a signature, missing a date next to a signature. I mean, we're talking nitty-gritty, nitpicky, tiny little mistakes that we need to be keeping an eye on, because in the event of an audit by the EPA, I mean, we're looking at, you could have $100,000 plus in penalties on one lead-based paint exhibit on one contract, right?
And also remember that if there is any sort of complaint, I was inside of a brokerage that, and I would imagine this came up because one consumer reached out, and it was enough of a potential problem that the EPA said, we've got to go in there and take a look. They don't come in and take a look at that one file that is the impetus for the complaint. What they did was make sure that the entire brokerage presented 2 years of all of their closings. They could have said three, since that's the statute of limitations. And back when this happened was when the files were still paper and they were in a filing cabinet. And so they just grabbed them all out and dumped them onto the table. Now it would be, 20,000 reams of paper printing every document that existed for all of those files for every agent within that brokerage. And I don't even want to think about the other technical, issues that may result when somebody's going through and doing a deep dive looking for those things. So it involves an audit that will disrupt the function of your brokerage company, definitely disrupt, your broker's time and ability to have some time to help you, because they're going to be sitting there with auditors going through files. So it is, the money thing obviously is important, but the disruption of business, and let us not forget that, doing this right is what we can do in order to protect homeowners from the potential that there is a very deadly thing that they may not be aware of, that they need to be concerned about. And they need to make sure that they safeguard themselves and take care. And I say that as someone who lived in a 1928 house. So I am sure that thing was chock full of lead, and it may not be that big a deal when we're first in there, but when we were redoing all of the windows in that house and going and peeling that back 70 years of paint, yes, there were several layers of that had lead in it. And so that is something that we needed to be aware of.
So, and along those lines, talk to me about the agents who attach the lead-based paint exhibit to every contract. Now, I will admit that I used to do that. We had received guidance several years ago that had said, cover your bases. What if it's a beautiful renovation that has an antique mantle, right? There's reclaimed wood fixtures in the home. Those could, in the event of a lead test, those could have lead-based paint on them. And so I did for a very long time. I attached to every single one of my listings, and I asked a seller to fill them out for my buyers' contracts for every single offer. And I know that we are now receiving different guidance because, quite frankly, the opportunities to make mistakes, especially if it's a house where it's not mandated, in other words, it wasn't built before 1978, it might be a smart risk mitigation policy or risk reduction to not attach it when it's not necessary. What are your thoughts on that?
So, and I was around when the guidance was. I wasn't doing as much of the teaching back then, but I was well aware of what we were giving out as guidance, because I was always answering questions for real estate agents, and I worked inside of real estate companies. So I was advising the brokers, even when I was probably a little too green to be doing so. So I learned pretty quickly. And we were most concerned about reclaimed and older items that have come in that a seller may not be aware of, that a buyer may not be, or that the seller's agent may not be aware of. So we said, okay, well, let's just paper over every single file that we do. But the way that we get guidance from the federal government as to whether we've done something right or wrong is guidance by enforcement,
Right.
right? They don't give us any explanations. They just tell us, they tell someone that they did it wrong, and we just hope we're not the someone that is the test case. And so what we are fearful of, and reasonable minds can disagree as to this, but what we are fearful of is that you will do it on a property that did not require it and do it wrong, and that the federal government will issue a monstrous size fine for this. And so, what we are now telling agents is you do it on every property that was built before 1978, and any property after that where there is the possibility, when in doubt, you do it. So, you know, you could have a property that was built in 2023, and if you are fully confident of the
Right.
fact that there is nothing new in it, it's, new construction, track building, this is not what it is that they do, then you would certainly be comfortable not to do it. But that does mean that when two agents are working in a transaction, one of them may be thinking the older way and one of them may be thinking the newer way. So, what I usually say with this is if you're dealing with a co op agent who is saying, no, you have to do it on everything, show a little grace. Because that was the process for a lot of
Right.
people, and not everyone got the memo because it wasn't a memo. And so, in that situation, just explaining, yes, we used to, but now the attorneys are saying not to do it. And these are the attorneys who are teaching real estate. And this is the reason for it. And there is a legal helpline on the Georgia Association of Realtors website.
Right.
Agents can reach out and ask a question like this and get an answer, and that may help as well.
And that is such a great resource that I wish that more of our members both were aware of and felt free to use when they needed it. And
Exactly.
lastly, because we have spent almost an hour talking about lead-based paint, and while that might not sound interesting to some people, I have found most of the conversation very fascinating. But I have one more question, because while we're on the topic of penalties, let's talk about the time period between April 24th, 2024, when this form mysteriously appeared on the EPA's website with no guidance from the EPA, no notice from the EPA. You'd think that they could reach out at least to NAR and its 1.5 million members, that they could say, hey, by the way, your members need to know about this. But of course they didn't. So here in Georgia, our new forms dropped on July the 1st, which means that from April 24th to July 1, we only had access to the old version of the form. So what are the chances, Cheryl? What happens if there is an audit of a company and the EPA comes in and they say, well, look at all these forms before July 1st. We dropped this form on April 24th. Is there any kind of a grace period we can cross our fingers and hope for?
I mean, you can definitely cross your fingers and you can definitely hope. If you are asking me to say that the EPA or any division of the federal government will show us grace, as a technical matter, ignorance of the law is not a defense. I would hope. I mean, all of the other changes that we make as an industry, we make it with, if an underwriter changes like their title insurance charge for something or something happens, there's always a grace period so that we can, I don't know, take a breath and figure it out and get things changed in our systems. I would hope that the federal government wouldn't be looking at enforcement in the 6 weeks from the time that this thing went live. Certainly, the defense would be that I was complying to the best of my ability. They may well respond that, well, we updated the form on the site and you're just supposed to go check it every day and see if anything got modified. So I don't like that as an answer. And then the only other thing I can say is by 2027, you'll be fine, because the document retention, it doesn't say the statute of limitations is 3 years, but what the law does say is that the document retention requirement is 3 years. And
Right.
so, from that standpoint, then they're not going to be able to ask you for anything prior to those 3 years anyway. And there are lots of times, I teach FREDA, I teach license law, I teach a lot of these things that are legal requirements that are codified under our Georgia code. And I will have agents and sometimes brokers come up to me and say, "Oh my God, I did that wrong." And you can't, I am not Cher. We cannot turn back time. But what we can do is do it right going forward. And that's the only thing that we can do at this point. And hope for the very best, but definitely make sure that we are locking this in as a process now, so that moving forward, because certainly once this form got revised and once everyone was on notice because the form that they were pulling in their system was revised and was new, and that line was there, you better have noticed it and you better have done it.
Right.
So just do better in the future, right?
Right. So all we can do is just hold our breath until July 1st of 2027, when the document retention deadline passes for the 8 weeks, 10 weeks, 6 weeks, whatever that was between April 24th and July 1st of 2024. So, well, this has been, I mean, I think even for people who maybe had some confusion about the old lead-based paint form, this has been really helpful. I love a deep dive into one document. And the thing that I love about this one, Cheryl, is that this is not just a Georgia form. Yes, we have the lead-based paint disclosure exhibit in our forms because we are required to, but this is a form that agents all across the country are required to use. And we didn't even really talk about the fact of the tenant version, but of course, that very closely mimics the buyer seller version, and it's just a different version that's now required to be used. So, do you have any closing thoughts?
Yeah, I was trying to put together, there's a couple of podcasts that I listen to where they do like a summary and sum up at the end. And sometimes that's kind of helpful. And it's something we can also include in the notes. But I think from my perspective in looking at all of this is number one, I think we get that our current forms don't necessarily address everything that we might want to do to help everyone comply with the law. So I think that those things will be coming. I think that I have said more times in the last 2 months than I have ever said, you need to lean on your broker. Your brokers need to be giving you guidance, and you need to be listening to the guidance that they're giving you, because there's a lot happening right now. And I what I see is a lot of brokers really focused on trying to help their agents do the best thing that they can. So show up at meetings, Zoom, in person, whatever, read the emails they send out, listen to the compliance notes that they're giving you when you go through the things. You are with that brokerage because they are providing value and education and protection. And we will put out some sample information for everyone because we don't mind sharing the secret sauce of we are much more focused on making sure this does right than
Right.
one realtor, has figured out a great way to do this. We want to make sure that everyone is doing this thing correctly. So all we have to do as we have changes in forms and changes in process is we have to adjust, lock in a new process, and then just, wash, rinse, and repeat it.
And I just want to echo one thing that you said that resonated with me is because things are a little volatile right now, and I've had so many conversations with our brokers and agents across our state. We are in a good position. Georgia's in a great position. We have some of the strongest forms I've ever seen, and I've seen forms from all around the country. But you said lean on your broker, go to the meetings, read their communication. But I would say same goes for your local and your state association. And I know that we are inundated with emails, and we feel like we're all drinking from a fire hose right now between NAR's guidance and things that you might be getting from your state and your local and your broker. Set aside maybe just a little time every day or a couple of times a week to just dig in and go through the information that you're getting, because ultimately, what does it help you do? It just helps you be better at your job. It helps you to serve your clients better. It helps you to be a better realtor. And then if you are in a position where perhaps someone's doing it the old way, or an agent that's sending you an offer is unaware of their obligation to initial that document, don't gamble on the fact that, oh, if they forgot to initial it, they're the one who will get the fine. You could also be fined because the mistake appears on a document that you've signed. So if we all just help each other a little bit, give grace, like you said, but also understand that when one of us improves, we all get better. And I think that that's kind of the angle that you and I have always taken with this podcast, with our teaching, with our conversations with each other. And it's something that I think as we move forward in uncertain waters, we should all just be a little more cognizant of.
Absolutely. Couldn't have said it better.
Well, thank you all for listening. Like I said at the beginning, we are back, baby. And we're excited that you're listening. We are going to put that information, it's in the show notes for you. We hope that you will take a look there. There will always be interesting information, promised information, links to great resources for you in those show notes. That is a resource for you. And of course, you can reach out to Cheryl and I anytime. And we're happy to be back. And we will be back to you again soon with our next episode.
Thank you guys. Bye.
Bye-bye.